All right, welcome, ladies and gentlemen, housing counseling agencies across the state. Welcome to the best practices to protect your client's privacy. Today, I'm Michelle Lewis. Most of you know me. I am the president of Northwest Counseling Service and the school director for the National Real Estate Institute. Joining me today are John Gorel, Esquire. He's a former counsel to Pennsylvania Housing Finance Agency. He has the benefit of being retired. And we also have Jada Greenhow, who is actually right now assistant counsel for the Pennsylvania Housing Finance Agency. So the purpose of this training is to be able to allow your agencies to understand all of the provisions under the Privacy Act, which you're subject to. That is one of the flow-through requirements that you are required to comply with under your designation as an approved HUD counseling agency. So most of what we're going to talk about today is going to be the Privacy Act of 1974. However, we are going to also introduce you to some of the state laws that that you should be aware of, and also the federal laws. And John is also going to talk about a little bit about data breach and how that affects us on a day-to-day basis. That's all of us pretty much. So let me give you just an overview of what we're going to talk about. We're going to talk about the objective of privacy and confidentiality as a policy. So each of your agencies should have a privacy and confidentiality policy. Again, one of the reasons that you're taking this training today is to be able for you and your staffs to have an encyclopedic knowledge of this law and how it applies to you. But it also allows your direct line staff who do not do counseling the ability to be able to handle sensitive information. And you will get a certificate at the completion of this webinar so that you have proof on your wall that you have been trained in confidentiality and privacy. So we're going to talk about the counseling agency relationship to the client, the covered client information and the staff that is covered, privacy and confidentiality, obviously, the Privacy Act of 1974, and the conditions of disclosure under that act. We're also going to talk about your HUD certification/approval, confidentiality of records, maintenance of files, maintenance of credit reports, and we're also going to talk about other state and federal laws and data breach. Now, I wanted to make one thing known. Make sure that you understand that we're not giving legal advice. We are just imparting information to you, really iterating pretty much what's in the law, what you're required to do. But if you want additional information, you'll have to go out and seek legal counsel, okay? So, what is the objective of a privacy and confidentiality policy? And what is the purpose of it? The purpose is to somehow be able to understand and let people know that they can trust you, right? To be able to maintain trust, to uphold your fiduciary obligation, and we'll talk a little bit more about that as we go along, to avoid misuse or abuse of access to sensitive information, to avoid apparent or the appearance of conflicts of interest, to avoid external access to client information, and also to avoid internal access to unauthorized persons. And we'll talk about who those unauthorized persons are and who those persons are that are authorized. So, but let's first talk about the counseling agency's relationship to the client. Now, understand that the client has a relationship to the agency, even if an individual counselor provides advice to that client. But the relationship is between the counseling agency and the client themselves. And what the agency owes that client is what's called a fiduciary obligation. And this is an obligation that holds the highest level of trust. It's the kind of partnership or relationship that has the highest standard of care. In this case, because you're providing advice in the areas of housing and real estate related activities, this relationship is somewhat unequal, meaning you have a higher obligation to your client than your client has to you. And that's because there's an understanding, or there's the expectation that because you've been trained in housing related matters, that you know more about housing than the client does. So that puts a higher obligation onto the counselor and or the agency when you're talking about partnerships, okay? Because the relationship with the client is a partnership, but this one is a little bit different in that it has this obligation of fiduciary responsibility. So, under that obligation, the agency has the obligation to place the client's needs above all else, including their own, which means whether the counseling agency gets paid for the service, whether they never see the client again, this obligation stays there, and it stays there forever unless you have something in your documents with your clients that limits that relationship in some way to a time frame. Otherwise, it can last forever. So, what are the agency's duties under this obligation? The agency owes a duty of care, loyalty, accountability, dependability, performance, and to act in good faith. These are the things that a client should expect from the counseling agency. So let's talk about for a minute a person in a position of trust. According to HUD, and I'll read this directly, this person is a participating agency's employees, including both paid and volunteer staff, consultant, officer, director, elected or appointed official, any member of their immediate families, or anyone who is in a position to influence a participating agency's decision-making process, or who has access to the agency's confidential client information. Now, why do I talk about a position of trust? It means that really in this context, we're talking about trust as it relates to the information that the agency is going to collect from the client and use to be able to provide advice. But all of that information is covered information, and I'll go through that, because it's not just the documents that you receive, the documents that you review. It's the conversations that you have, whether they are in-house or with other clients, right? So whether it's a conversation with another staff member, with someone on the janitorial staff, someone in your family, in the client's family, all conversations are covered with respect to any information that is gathered with respect to that client. Obviously,
Michelle, you raise an interesting point. Does this duty of confidentiality extend to a counseling agency's vendors?
Absolutely. And Jada, thank you so much for bringing that up, because that's a good point. It also extends to anyone where an agency or a vendor that an agency uses to store information that may be relevant to the client. Now, many of you have 3 or 4 different case management systems that you have to go into, but RX, all of you are required to use RX, okay, in that vendor relationship. And so it extends, yes, to those as well, not just inside of your office. So Jada, thanks so much for bringing that up, because I don't even think we were going to cover that. So thank you.
No problem.
So it also covers demographic information individually or in aggregate. And you pretty much know what demographic information is. But let me just say that demographic information to you mostly is name, address, telephone number, head of household, whether they're a senior citizen, their age, and all of those other things. But in aggregate, that means in a system of data, okay? And a system of collected data, which means that, say that at the end of the month, your agencies will run a report that shows you the number of people that you've serviced, how many were low income, how many were above 30% of the median income. all of that information, even though it doesn't itemize the individual client's name, that is protected information as well. And that's what they mean by in aggregate. Okay? The client's circumstance, whatever they're coming to you for and that they're disclosing to you, they want to be sure that that information that they are sharing with you, this private information that they took enough time to be able to share with you, they want to know that that's protected and that you're not going to share that with someone else. Their file, all of the information that we put in the file, and let me just say too that the file is not just the physical file that you put together with the intake form and authorizations and all of that. The file also includes any extraneous information that you may have written about the client, like on a side sheet of paper that you may have written down. Client file means in the case management system that you're using, right? All of that is considered the client file. Obviously, the credit report, and we know that we have to get their permission to even run it, but even to share that information, also, it is protected. And any and all other information pertaining to the client, whether obtained verbally, in express form, which is written form, or electronically.
So Michelle, it sounds like any information that can be used to identify an individual is covered by what you're saying here.
Absolutely. Every single piece of information. I think yesterday, John and I had a conversation about whether or not dogs would be include dogs' names.
No, I said dog names because a lot of times people use their dog's name as part of their password.
Password, so forth.
It was a stretch, but
It's a stretch, pardon me, but the irony is that that's also protected information because, as I responded to you yesterday, if, say, the counselor is putting down information on a separate piece of paper about a client, and maybe they're going over the budget and what they spend, and they happen to spend a lot of their monthly income on pet supplies and pet food, right? And then the client may have mentioned the names of their dogs, and the counselor wrote it down. Well, the reason that paper is protected even with those dogs' names is, what if the secretary at the front desk happens to know this client, right? And they walk by and they see this piece of paper and see the names of their dogs, which they happen to know the names of their dogs, but also this little scribble about how much money they were spending is also on that piece of paper. Do you understand what I'm saying? So even the names of those dogs really can help to identify a person, even though that is a stretch.
if I could bark up a different tree here, many years ago when I was back here at PHFA,
Yeah.
it doesn't matter what the intentions of the person are, whether they're laudatory or not. For example, the HEMAP information. People
Right.
would apply for HEMAP and either get approved or denied or what have you. Well, certain people out there, attorneys, legal services attorneys or what have you, they would have loved to get a list of people who applied for HEMAP to help them.
Right.
You know, to help
Yes.
them maybe file an appeal or do other things. But that's confidential information.
Exactly.
So we had to say, no, I'm sorry, even though it's with good intentions, we can't give you that.
Absolutely. Absolutely. And that's exactly what we're talking about today. Who are the covered staff? Counselors, supervisors, executive level staff, clerical staff, processing and billing staff, volunteers, and anyone obtaining access by or through a counseling agency. And again, or through is very important because, again, we submit information into a case management system that collects information about individuals. And so that's through us that we are sharing that information. So, privacy. Okay, and I'm going to actually read this definition according to Merriam-Webster.
Which is not the same person.
And tell us why, or tell us the story.
Actually, there were two Miriams. There was brothers who started Miriam Publishing Company, and they had a dictionary. Later, back in the 1800s, Mr. Webster had his own dictionary company. He died. His estate sold the rights to Miriam Brothers, and they then formed the Merriam-Webster Dictionary.
Okay,
It's
so,
1831 for anybody.
so now we know that bit of information. So now we're designated smart. Okay, so according to Merriam-Webster, privacy is described as the quality or state of being apart from company or observations, in other words, seclusion, and freedom from unauthorized intrusion, one's right to privacy. Okay, so this is what they describe as privacy, that information that should not be shared with unauthorized individuals. And we'll talk
You're
about.
hitting on the point. Unauthorized is the key here.
Yes, that's the operative word.
It is.
Is unauthorized. And we'll talk about who's authorized, right, under what conditions, right? And even some that may be authorized, there may be limits to that authorization as well. So confidentiality, Merriam-Webster, as marked by intimacy or willingness to confide, to private or secret, containing information whose unauthorized disclosure would be prejudicial to the national interest. Now, I know that probably our clients' information wouldn't necessarily be a danger or prejudicial to the national interest, but it certainly is absolutely important to them. You know what I'm saying? That we keep that private.
Michelle, I think this definition really gets to the spirit of what these laws are designated to protect, which is someone's willingness to confide this information to obtain the help that they may need.
Absolutely, absolutely. Yep, and we have to, obtain information from the clients in order to be able to help them. But we have to make sure, number one, we identify them, that they're the same person who's tied to the real estate that they came in with respect to, and that they are authorized even for us to talk to them about their situation, in addition to the privacy and confidentiality that we have once we've done that, to the information now that they share with us. So, there's a lot around this. Client privacy at the facility. Now, this is what HUD determines as a private session. A private counseling session, ideally, should be held in a private office with a closed door that allows no discussion within earshot of other staff or others. In other words, it means having a door that actually prevents other people on the other side from hearing the information that is shared. But anyway, we have got to protect the privacy and confidentiality of client information in scheduling, in the course of intake, inside of workshops, inside of our management of their case, and inside of managing the files, because there may be other people that may have access to putting their hands on the physical file to get filed, right? And again, this is one of the reasons we're doing this, is once you get this training, and I hope I'm also talking to direct line staff who are not counseling staff, but who assist or want to assist counselors with their work, learning about this law and being able to get this certificate allows you to be able to have access to this sensitive information to assist the counselor in this. Now, understand, though, the same obligations stretch to you, too, these same obligations, which is why you're learning this, okay? So it really stretches way across, and sometimes you really have to save the client from their self, so to speak, in that sometimes, like in a workshop situation where you have a group of people, some clients want to outwardly share their circumstances, but we are required to limit that as well, and to make sure that clients don't disclose their own information in front of other clients, and that, we stop them. Sometimes they have questions for us, that are of a personal nature or about their individual case, and what we have to do best we can is to say, I absolutely want to deal with your question. We'll be able to, as soon as we break, I can take you in the other room and we can discuss it, okay?
The other thing too is if you have a client coming to see you, and you're meeting them at say a waiting area of some sort, they need to wait till they get back to your office with the door shut to start telling their story.
Absolutely.
They want to get out everything as quickly as possible, but just, got to slow them down and say, well, wait till we get in my office, and then we can talk.
Absolutely. And the same thing for the counselor or whoever is, getting information from them, the same thing. That we make sure that we're not collecting information from them in front of other clients in that waiting area as well. So thanks, John, for bringing that up. So anyway, the client privacy at the facility means no discussion or disclosure to others without their prior written consent. Okay, they have to consent. And that includes spouses or other interested parties, other relatives. We have to observe the workshop privacy rules, and as I said, you should have a policy around how you handle workshops. How do clients in a group protect their information from being seen by the next person? And how do you help them to do that?
Now, that's very interesting that you mentioned spouses or other interested parties such as family members. Can you elaborate on that?
Yes, absolutely. Many times you'll say your client is the person that came to you and said they have this particular situation. Now, they may be in the middle of a separation, and the husband happened to find out that they were coming, and now the husband is trying to get information about the client. Same thing with a neighbor, a newsy neighbor, may want to try to find out information about what the client is talking to the counseling agency about. This stuff happens all the time. And so those people are not actually authorized. You're not authorized to give those parties unless your client specifically gives you authorization to give them information.
And as you mentioned previously, even the information that you are permitted to share may be limited.
That's right. That's right. It absolutely can. And the client can limit that in any way. They can say, well, I'm allowing you to be able to give them information only that I'm in default. That's it. Not the amount that's due, or any of that information. They have a right to be able to limit that information too.
The last bullet is interesting too, because a lot of times offices today, basically everything gets shredded, which is good. It should be.
Yeah,
But a lot of times the waste paper basket is not shredded.
right.
And as you're on a phone with someone, it's just human nature to write down phone numbers and client name and maybe even a social security number.
Right.
And then once it's entered into the system, you throw that away. No, that should be shredded as well.
Absolutely.
Because somebody could go through that trash and discover what is otherwise protected information.
That's right. That's absolutely correct. That's absolutely correct. And what John is referring to is the last bullet here that says client information must be kept completely away from unauthorized view. And that includes the waste paper basket.
Right.
Your desk, okay, like it says here, left open on desk or otherwise exposed. And that's the same thing with electronic information. You may, when you get up from your desk and you have a client's file open in RX, you need to lock your screen until you come back from lunch or your break, wherever you're going, to protect that client information.
So, Michelle, what if someone compiles a file and they don't leave it out on their desk, but they put it in an unlocked drawer? Is that acceptable, or should the drawer also be locked?
Well, technically, HUD requires all of those files to be in a locked area, meaning either in a locked cabinet or a locked room, okay, but not on the counselor's desk.
Okay.
Or not on the, the receptionist's desk, who may be scheduling people. So this comes with a lot of responsibility. It really does. So the Privacy Act of 1974, which again, we're going to talk about a number of different laws, but this one is most important to counseling agencies because this is the one that HUD, under your HUD approval, is requiring you to know and adhere to in your practice. So it governs the collection, maintenance, use, and dissemination of personally identifiable information about individuals maintained in systems of records by federal agencies. It prohibits the disclosure absent the written consent of the subject individual. It provides individuals with a means by which to seek access to an amendment of their records, sets forth various agency record-keeping requirements, And everything we talked about before this was federal agencies, right, that it was subject to. But this last one is where it hits you. A pass-through to subrecipients of federal funds. So that means a subrecipient of any federal fund, you are subject to this rule.
So all of the council agencies are in fact subrecipients,
Absolutely.
because PHFA
Yes.
is the recipient.
That's
and
right.
they pass on funds to them.
That's right. There you go. Conditions of disclosure. No agency shall disclose any record which is contained in a system of records. Let me stop right there for a second. A system of records could be a full system, right? It could
Such
be.
as a vendor management.
That's right, a
type
case management
case
system,
management
as you
system.
brought up earlier. It could be how you keep your physical files, you know, the order in which you keep your physical files. But it also could mean one individual file, okay? Even though it says a system of records. But the reason system is important is because any one person that you take information from, even if it's only one, you are subject to these same obligations, okay? And so, you know, it's also considered a system, even though it's just one person. It's still considered a system. So I just wanted to stop to make sure that we explain that. So, in a system of records by any means of communication to any person or to another agency, except pursuant to a written request by or with the prior written consent of the individual to whom the record pertains. So very simply, that just means the client. Any information that the client has given us. So, under your HUD certification / approval, it requires that no person except the counselor and his superiors shall have access to client data, and the superiors on a limited basis. The exceptions are the counselor superiors, intake persons who have been trained in requirements of the Privacy Act, okay? Trained in the requirements of the Privacy Act, which is why we're doing this right now, okay? We are making sure that those intake persons can support the counselors in their day-to-day counseling activity and be able to still comply with the requirements under this act. HUD and its personnel and government or by contract. Now, what does that mean? That means levels of government that may be able to gain permission to these files for specific purposes, or by contract. And contract is, as an example, you all have a contract with the Pennsylvania Housing Finance Agency. And through that contract, the contract requires that you operate under the participating agency agreement. It requires that you meet the requirements under this Privacy Act of 1974, but PHFA actually goes a step further and even though they require and can collect data and information from you as a counseling agency about clients, they actually have created forms for the counseling agencies to use in order to actually get that authorization at the client level, okay? And here is an example, and most of you have already seen the 3-in-1, or you should have, because you're required to be using it. And I'll just go through generally what it contains. The first section talks about how the client's information is going to be used, right? How we're collecting information, how that client information is customarily used, and so forth. And this is what allows us, by the client's authorization, to be able to give PHFA access to the information as well.
This is just to point out, that this is something that you should go over with the client.
Oh, absolutely.
Because a lot of times, you know, a form is put in front of them, and they just sign it.
Right.
You really should go over it with the clients so they understand what they're signing.
That's
and
right.
what the obligations are.
John, I'm glad you said that, because actually you should be, now this actually should be done by the counseling level individual, not like an intake person, because they do need to be able to explain to them what this form means. And because here on this, and this is actually part of the first page, of this document, it goes down through a list of things that the client has to initial to say that they understand that they were given all this information. They were told about the privacy and confidentiality policy.
And Michelle, is this something that's obtained from the client prior to the initiation of the counseling session?
Absolutely.
Or at the end?
Nope, absolutely at the beginning.
So
Good
this
point.
gives the counselor the right to even acquire this information
From
the
them.
client.
That's right, because up until then, we don't even have permission to get that information. Do you know what I'm saying? We
Right.
don't even have permission yet to
So
get
it's
it.
critical for the counselors to remember to obtain this document and go through it with the client prior to accepting any client information.
Absolutely, absolutely. And the client in PHFA, said for me to make sure that I remind everyone that the client actually should be initialing this, not like just checking the boxes, but make sure that the client actually initials. And they're not going to initial every single one because, for instance, this particular client may have come in just for homeowner counseling, and so they would initial that section there. But the others, I understand, I have received, all of those need to be initialed by the client
So
and signed.
the bolded areas, each one should be initialed. But beyond that, only the service that's actually being provided, or the counseling service
That's
that's
right.
actually being
Pro-
received,
yes.
should be initialed.
There you go. The second part of that, or the other parts of the 3-in-1 form, explains to the client also the types of information that the counselor is going to be gathering about them, offering them to opt out, that the client can opt out anytime they want to share information with this person or that person or give certain information in a certain way. They do have the option to opt out, and we have to let them know they have that option.
So they can essentially revoke the authorization for the counselor to access certain information as well as the sharing of that information?
Yes. So, but then it also talks about how we in the counseling industry use the information and what we use it for. And of course, at the bottom of that is an actual client authorization that they understood now all of the provisions of this. This is a new form that was created by PHFA that also has to be initialed and see if it has to be signed at the bottom. But what this is an agency disclosure, and what that means is that the agency is disclosing to the client any financial or legal relationships that they may have in other divisions that they may have in their agency. They may have relationships with lenders or other vendors that the client may come in contact with, and this all has to be disclosed. Every single one of those persons, and the client needs to know that they are under no obligation to use any of those services whatsoever. So this is an important disclosure, and this is one that is a sample that PHFA has provided. If the agency has its own disclosure, it can use it.
Now, do those disclosures have to be approved by PHFA, or they can use what they have, the counseling?
They have to either use this, or the language has to be substantially equivalent to what's contained in this document. So it has to be one or the other. And another new page, which the counseling agencies have not, all of them have not gotten to share yet, is the client engagement form. And that really talks about how the client is going to engage with the agency, where the client is agreeing to a specific number of sessions over a specific number of time to talk about financial education and information, in addition to specific one-on-one counseling that they may get with the counseling agency. So let's talk about HUD's definition of privacy. HUD says, to ensure the confidentiality of all client-level and agency profile information, you must use a case management system which has taken all the standard and required security protections. And you have to provide assurances that this data will not be shared with any entities other than HUD and the counseling agency unless explicitly instructed to do so by the client. Now, we do share with Pennsylvania Housing Finance Agency, and as we just talked about, that is by individual client disclosure. In the case of agency information, That is the housing counseling agency that they are talking about. But in other words, to Jada's point earlier, that case management system also is a flow-through entity that must meet the requirements under the Privacy Act. Any information about an individual maintained by an agency used to distinguish, trace, or identify an individual's identity, including personal information, which is linked or linkable to an individual. So remember earlier when we talked about the dogs and the names of the dogs and how that actually could be linked to that individual. Now, we know that probably most of the time that's kind of rare, but it actually is applicable because it's a way to identify that individual. What is personally identifiable information? PII, it's otherwise called, includes the name, email, home address, telephone number. Sensitive PII includes, if standalone, a social security number, a driver's license or state ID, a passport number, alien registration number, financial account number, biometric identifiers. If paired with another identifier, it can be citizenship or immigration status, medical information, ethnic or religious affiliation, sexual orientation, account passwords, last 4 digits of social security number, date of birth, criminal history, and even the mother's maiden name. And like John said earlier about the passcodes, you know, a lot of times when you're setting up these accounts, they will ask you for your mother's maiden name or some other question like that.
Right.
And so that information is very sensitive.
Well, in my case, the people think that I'm trying to throw them off guard because my mother's maiden name was Glebshinsky.
Yeah.
And I have a hard time spelling it myself, and I know how to spell it. But all these things, if you remember back not too long ago,
Yeah.
everything was identified by your social security number.
Yep.
Your student loan number was your social security number.
Yep.
Your bank account was social security number. Your
Yep.
loan number oftentimes was social security number. And now you have account numbers so they're not personally identifiable to you.
Exactly.
And that's why that switch was made, to protect people's privacy.
Absolutely. Absolutely. And even in the HEMAC program,
Yes.
right? Same thing. Same thing in the HEMAC.
And the trouble is sometimes you send out, lenders, let's say, are sending out a statement for the monthly payment. Well, if the paper inside slips down a little bit, you may see that account number. Well, if it's a social security number, that's horrible. I mean, that's
Right.
a terrible thing that can happen.
Absolutely. Absolutely. And I just want to mention something because actually an instance came up about this just yesterday. And it was an instance where a counseling agency was faced with a situation where the client disclosed inside of the counseling intervention that she felt suicidal, that she felt like hurting herself. And so I talked about it with that person in the context of privacy and confidentiality, because what they ended up doing, she did end up leaving the agency, and they called to find out what they should do, and they were told to call a crisis center and to do a 302, an involuntary commitment. But they had to share the client's information with law enforcement, right? Because once law enforcement has that information about this person who may be a threat to themselves or others, law enforcement has to go and arrest that individual and take them into custody and to be able to help them, okay? And so that's a sensitive area, right? Like, do you disclose the information, do you not? Number one, every agency should have a policy on reporting. How to report, when to report, if we report. Do you know what I'm saying? If we're required to report. Some agencies, by the nature of the things that they do, some agencies are full-fledged social service agencies, so they're required to report child abuse, domestic abuse, and just the whole string of things. Every agency should have a policy on reporting. If we report, when we report, and how to report, and how to handle such situations, and make sure that we are staying within the compliance of being able to share sensitive information when it comes to life and death.
And it sounds like there may be situations where a counseling agency may even be required to share some information.
Yes, when it comes to life and death, or the threat of life and death, then you may have to share information with those that may be able to help them in their situation. It could be the crisis center itself, maybe not the police department, but it could be the crisis center itself, because you may have someone in front of you that's so highly agitated they can't even repeat their name. So that's a sensitive one, but that just came up recently. Social security numbers, this is the confidentiality of records, includes social security numbers or comparable identification numbers, financial information associated with individuals, medical information associated with individuals, which also is protected under HIPAA. We're not going to go over HIPAA in this particular webinar, but HIPAA is another a section of privacy that the counseling agency should know about. You're not required to have HIPAA certification under your HUD approval. However, as a good agency understanding all of those things that refer to you, it's a good idea that you get training in HIPAA as well. So,
And even though sometimes people are trained, you go to your medical doctor's office, for example.
Yeah.
And those people should all be trained regarding HIPAA.
right,
So when you come in, you sign the HIPAA forms and so forth. Well, when it comes time to your turn to go back, they yell out your name.
I know, I
So
know.
what happened to HIPAA?
I know. Well, a lot of them have changed that now, some of them. You know, now they have the little white strip that they
Right.
turn
Right.
off, and now you write
I was
that.
at one where a number came up.
Yes, or where your number comes up on a screen or something, now you're a number instead of a name.
Right.
So, yeah, the medical industry is dealing very heavily with HIPAA. So anyway, medical information associated with the individual's sensitive personal identifiable information, any subset of PII requires additional levels of security controls. So in other words, what they mean by that is, okay, there are different levels. And remember on the slide where we said if seen alone, say just one thing, it's personally identifiable information, but it doesn't become sensitive until it's combined with something else. We are also, as counseling agencies, required to ensure that the CMS systems, which is the case management systems that we're using, protects the confidentiality of each client's personal and financial information, both electronic and paper, including credit reports, whether the information is received from the client or from some other source. We have to ensure that neither they nor the CMS vendor discloses the information in the client's individual case file to anyone except for authorized agency personnel and HUD. We also have to ensure that the selected case management system maintains the confidentiality of this information as well. So in our case, that would be certainly RX. You know, some of you have other case management systems that you're using side by side, but you're required to use RX. The only exception to this requirement is when the counseling recipient expressly grants permission, for example, in the case of through a case management system, the automatic creation of a loan application and submission to a lender. So what they're talking about is, like, remember in HCO, for those that used Home Counselor Online, there was the ability to generate a 1003 when certain data was collected inside of the counseling side.
Michelle, what is the 1003?
The 1003 is the Uniform Residential Mortgage Application, or at least that's what it used to be called, right? Under the
You don't
new.
want to date yourself.
No. So, yes, counselors had the ability to actually generate a uniform residential mortgage application on behalf of the client. Now, theoretically, that could go to a lender that is inside of that system, which means it's sharing information. Do you know what I mean? With another entity. So what this is saying is you have to have express permission to be able to do that, to share information like that. HUD staff may not disclose to anyone except to authorized HUD personnel the information contained in individual case files that may be sampled as part of monitoring or received as a part of reporting. So HUD also, even though they have this ability to get the information from us, there are limitations for them too, that they can't share this information or use it for any other purpose other than monitoring for those cases that they're looking at. They can't do that either. So what about the maintenance of files and records? HUD requires that you maintain a separate confidential file documenting each unique, distinct provision of counseling services provided to a client. Maintain a separate confidential file for each course provided. Hard copies of client files must be kept in locked filing cabinets, and remember you talked about this
Yes,
earlier, Jada? And electronic client files must be kept secure and be accessible only by authorized individuals. So even if it's in a locked room, it can't be where everybody in the office has a key to that room. It's got to be only authorized personnel.
Now, Michelle, is there any type of retention requirement for these files? Or
Yeah.
should the counseling agency consult with counsel or other staff to determine how long they have to maintain these records?
Well, and that's a good question. And file retention can be different with each entity. HUD requires 3 years, but they may be under contract with other entities that require longer.
Okay.
So I always tell people, in your policy, you should err on the side of the most restrictive. Meaning that if one of them says 10 years, then I would err on the side of doing the 10 years as opposed to, say, 3 that HUD might require.
So go with the more stringent requirement
That's
for
right,
record retention.
yeah. And that's, anyway, my own 2-cent recommendation. So, we must, and everybody knows this, secure the client's authorization prior to ordering any credit report at all. Failure to maintain the confidentiality of or improper use of credit reports may subject the agency to penalties under the Fair Credit Reporting Act. And see, these are other acts that you're subject to as well. And this is the thing. In this webinar, we're trying to give you as much information about client confidentiality and privacy as we can. But understand that there are other rules and regulations and laws that affect your practice. And it is incumbent upon you to seek out those areas and make sure you understand the laws that relate to your industry and or those laws that relate to similar industries that you have to interact with. Why? Because you have to make sure that, say, that you interact with attorneys, right, that do certain work. You do work in mediation courts, right? But you have to make sure that you're not crossing the line between counseling practice and legal practice. And the only way to know that is to understand the provisions of both. You understand what I'm saying? So some of these things, we're giving you best we can, what we can. But I'm also suggesting to you to make sure that you go back and look at these other laws too, like the Fair Credit Reporting Act, to make sure that you know what they mean in your day-to-day practice as well.
And you have to be careful about asking for a credit report on someone. There are only certain reasons why you can legitimately do that.
Yes.
But, and one of those legitimate reasons is not trying to find out what your neighbor's credit report is,
Right,
or what your future son or daughter-in-law's credit report is.
right.
So you can't, it's not something you're gonna play Nancy Drew here and find out information about people just because you wanna know.
Oh, absolutely.
It has to be for a legitimate
It
reason.
has to be for a real reason.
Right.
That's right. Good going, John. We also have to ensure that neither they or the vendor, the case management system vendor, discloses the information in the client's individual case file to anyone except for authorized agency personnel and HUD. Otherwise, it is subject to all other privacy and confidentiality rules. So credit reports have special protections that are around those. But what you have to just remember is it is all private and confidential.
Well,
And you're
Michelle,
not,
I'm sorry, I have a question.
Yes.
So is a faulty CMS system a defense for the accidental or unauthorized disclosure of PII?
actually, I don't think so. Because HUD is, and that's why they're explicitly saying this here, is that HUD is putting the onus on you to make sure that this flows through responsibility and obligation flows through to whatever vendor you use. So they are looking to you to find out and get assurance from your case management system provider that they are complying with the Privacy Act. of 1974.
So in other words, the counseling agency needs to ensure that not only its staff and its systems are compliant, but that may trickle down to ensuring that a CMS vendor is also compliant.
Absolutely, absolutely. And HUD made it very clear that they are expecting you to provide that assurance. So that means you're the one that has to do the work to make sure that case management system is compliant. So it probably might not be a good defense, even though, I mean, I would
You
still
can make
use
a
it.
defense.
I would still use it.
However, it may
right?
not be successful, is what
It-
you're saying.
That's right. I love the way you think. I love it. Okay, so now we're going to bring Jada up. Thank you so much.
So Michelle did an excellent job of explaining best practices and what policies a counseling agency should have in place. But let's say you're a counseling agency and you do all these things. What happens if there's still a breach of your systems? So states have addressed this concern. What should a counseling agency do in the event of a breach? So all states now have some form of data breach statute and some notification requirements. There are also federal laws and entities that do protect certain types of data. As you'll see from the PowerPoint, the FTC and the FCC have some regulations in place. There's the Health Insurance Portability and Accountability Act of 1996 that John referred to earlier. That's HIPAA. And then there's also Graham-Leach-Bliley. So in December of 2005, the Pennsylvania legislature enacted the Breach of Personal Information Notification Act, which we will refer to here as the PA Breach Act, and that became effective in 2006. So what is the scope of the PA Breach Act? Who does it cover? What does it do? What is it designed and implemented to protect? So it describes which entities should take action, what specific actions entities should take, so entities meaning a counseling agency, and when those remedial actions should be taken. The legislation describes the general rule, and what it says is an entity that maintains, stores, or manages computerized data that includes personal information shall provide notice of any breach of the security of the system following discovery of the breach of the security of the system to any resident of this Commonwealth whose encrypted and unredacted personal information was or is reasonably believed to have been accessed or acquired by an unauthorized person. Notice shall be made without unreasonable delay. So there was a lot of information contained in those two sentences. So we'll go over each of these bolded terms to determine whether the counseling agency is covered, which I can tell you it absolutely is, what exactly is covered, and what to do in the event of a breach. So an entity that maintains, stores, or manages computerized data that includes personal information. So an entity covers Pennsylvania governmental agencies and political subdivisions, businesses, financial institutions, and individuals, and of course, the counseling agency. So this trickles down to the counseling agency, its staff, and as Michelle mentioned, potentially even vendors or anyone that has access to the counseling agency where data is stored. What is personal information? Michelle gave you the chart several slides ago. So personal information excludes publicly available information. A person's first name or initial and last name and any of the following elements, if not encrypted, would become personal information. So that's social security number, driver's license or state identification card number, or financial account number, credit card number with a security code, access code, or password permitting access to the account. So essentially, all of the information on Michelle's chart is covered by this PA Breach Act. What is a security breach? So as Michelle mentioned, files really should be contained in such a way that they're not easily accessible. So that includes locked drawers. They shouldn't be left on desks, out exposed for anyone to come in and open the file and access this information. So a security breach is any unauthorized access and acquisition of computerized data that materially compromises the security or confidentiality of personal information maintained by the entity as part of a database of personal information regarding multiple individuals, and that causes or the entity reasonably believes has caused or will cause loss or injury to any resident of this Commonwealth. So essentially, if your systems are breached, if someone somehow gains access to your CMS system, that constitutes a security breach. If someone gains a last name and a social security number, that's a breach, and notice has to be provided if that information is unencrypted. So encryption is the use of an algorithmic process to transform data into a form in which there is a low probability of assigning meaning without use of a confidential process or key. So if you're maintaining information on your CMS system, if you have a file and someone accesses it and they get information that they wouldn't ordinarily be able to obtain publicly, that constitutes a security breach.
So Jada, to have a security breach, it's not an intentional act. It could be unintentional.
It could be unintentional.
It could be a theft.
Absolutely.
For example, a lot of times today, people do a lot of work on your laptop. And on the laptop, they may have files that contains personal information.
Absolutely.
Well, then, obviously, you need to have your laptop have a code to get access to it. But more than that, don't leave your laptop in the trunk of your car or in the back seat of your car. Because if your car is broken into and that laptop is taken, that information is taken. And that's a breach.
Or leaving your laptop unlocked on your desk and someone happens to walk in, they're seeking counseling services and they decide, oh, here's a laptop, let me scroll through. If someone accesses a name, phone number, home address, paired with some other type of sensitive PII, that's a security breach.
I mean, I know security codes can be a pain, or they seem to be a pain.
They can
But
be.
they're very valuable, and you should use them, even on your home computer for that matter.
Not only are they valuable, they're critical and arguably, as Michelle would probably say, required in a counseling agency scenario. So redact. Redaction may be important in certain situations. And what is that? The alteration or truncation such that no more than the last 4 digits of a social security number, driver's license number, state ID card number, or account number is accessible as part of the data. So, redacted data may not be as sensitive as unredacted data. That doesn't mean that you should use less protections. However, there may not be as much exposure there. And records, of course, as Michelle described, could be a written record, it could be verbal, it could be recorded, it could be the scratched piece of paper where John has written down all of your dog's names and
Keep coming back to that.
That's right, John.
that information constitutes a record. And the Act mandates that you provide notification without unreasonable delay. So unfortunately, unreasonable delay is not defined, but the law does recognize that an entity may take measures to determine the scope of breach and restore reasonable integrity of the data of the system. And there is an exception if a law enforcement agency advises in writing, and also that law enforcement agency is required to cite this provision of the PA Breach Act, indicating that providing such notification might interfere with an investigation. So there may be a reason why law enforcement says, don't provide notice just yet. We're still trying to determine the scope of the breach, who was affected, or who actually committed the breach. So there may be a reason, and if you have that documentation in writing, then it's okay to delay providing that notice.
But just hoping that someone doesn't find out about it is not a reasonable delay.
That's exactly right.
You need to take action right away.
Right.
So, disclosure to consumers. When is disclosure required? When is disclosure of a breach required? So, the PA Breach Act says that the notification requirements are triggered when there is a breach of the security of a computerized data system. So essentially, the moment that you know or should have known that your CMS system or a file was accessed without proper authorization, these notification provisions are triggered.
So that means that for counseling agencies, they're subject to the same things that may have, like, recently happened in the Wawa data breach, as an example, where they had to notify all of those customers that the information had been breached. So counseling agencies are not immune from that. A lot of times in the nonprofit arena, we kind of don't position ourselves with a Wells Fargo or one of these giant companies who have these data breaches and have to notify all the people. We are just as subject to that as anyone else. Is that correct?
Absolutely. You know, you have to remember that what we're doing is protecting people's data. So regardless of whether you're a big entity or a small entity, that doesn't mean that the ramifications of exposure of someone's data aren't the same to them.
Got it.
And that's a critical consideration when you take the data, when you hold the data, and when you maintain personal data. So, as I mentioned previously, there is a law enforcement exception. If law enforcement indicates that there's some reason to delay providing the notice, a counseling agency may do so. But again, that delay needs to be in writing with a citation to the statute. So how is notice provided? An entity may provide written notice, and that can be to the last known home address for the individual. And there may also be telephonic notice. Of course, the entity has to have a reasonable expectation that that telephone number is correct and that the individual will receive notice at that phone number. Email notice may also be provided if there is a prior business relationship between the counseling agency and the individual. And there's another provision regarding substitute notice. So again, email may be a form of substitute notice, but posting on a website and providing notice of the breach to statewide media. However, you can use this substitute notice only if the cost of notice will exceed $100,000 or the number of people that need to be notified exceeds 175,000, or if the entity doesn't, for some reason, have contact information for the individual. Civil relief remedies. So, violation of the PA Breach Act are actionable under PA's Unfair Trade Practices and Consumer Protection Law. There is no private right of action currently. So what that means is that an individual can't sue a counseling agency and obtain some type of personal relief for a breach of the act. The exclusive enforcement is by the Office of the Attorney General. And some of these actions may include injunctive relief to compel an entity's compliance with the PA Breach Act or take reasonable measures to prevent further violations. And there may be some civil penalties for an entity that purposefully fails to comply with the PA Breach Act. And I will hand the podium off to John.
All right, thank you. It's a pleasure being here. I want to just correct one thing. I was never counsel for Pennsylvania Housing Finance Agency. I was only associate counsel. But I didn't ever wanted to be the counsel, as a matter of fact. All right, outrageous breach of privacy. Here's a cartoon that I saw that I thought was apropos of today versus yesterday, or very yesterdays, you know, where someone would, you open up your door and there's the entire address book and telephone numbers of everyone in your area is right there on your doorstep. I don't even know if they do that anymore. I think they used to do yellow pages now.
I've seen a telephone book.
So Michelle mentioned the Wawa incident, which is very, very recent, that there was a breach of privacy with the hacking into their computer system. Before that, it was Home Depot. The effect upon Home Depot was their stock went way down for a time because of that breach of confidentiality, breach of protected information. And there were a lot of people, and they're still reeling from that, actually. Their stock is below what it should be, according to the stock analyst. But it stems back to that time of the breach of information that was released. There are several existing federal privacy laws that are listed here on the next few pages. I never, before looking into this 5 years ago, it's the last time we did this presentation, there is a privacy law for all seasons, pretty much. And they're listed here: the privacy of communications, children's privacy, financial institution privacy, government collections privacy, miscellaneous medical records, which is HIPAA, I mentioned that previously, and it goes on and on and on. Now, like most things, these privacy laws are not as prophylactic as you would hope they would be. even given all these laws and all these statutes and that were enacted by Congress, we still have violation of privacy. Every day, there are things that are breached, that are hacked into, despite these laws. So you can't sit back and think, oh, I'm protected by federal law. Yeah. That is not going to work. It's not going to, prevent a violation of privacy, a release of unauthorized information. Really, you all are the ones that have to prevent that from happening. The statutes will not do that. I think this is a fairly comprehensive list of federal law, and I'm not going to go through all of them because they'll be in the PowerPoint presentation, and you can read those for yourself. One thing that is next, though, would be, if you want to jump ahead there, you already did. You read my mind, Jada. There is a chronology of when there is a data breach that has to be reported. And those data breaches appear on this Privacy Rights Clearinghouse. And it's amazing that, first of all, the number of data breaches that exist and how they occurred. They tell you the sort of circumstances behind what happened, how the information was released. A lot of time it is something as simple as a stolen laptop computer. Mm-hmm. Sometimes it's more elaborate, where hackers are trying to actually commit theft by stealing the information. So it's a whole wide panoply of things that can happen that result in a data breach. But if you want to go to that website, it is a very, very long, but it's a very good examples of what can happen and what you all should try to avoid happening with your agency. One of the reasons that hackers go in and get into this business is obviously they're not doing it as a pastime. They're trying to make money, off of your name, off of your social security number, your clients' names, their social security numbers. And on this list here, it shows you, as of 2020, I believe, I think we updated this recently, yeah, we did. The average price of what different things are worth. A mother's maiden name is worth $3. A social security number is worth $3. Driver's license number, more valuable, that's $8. Criminal background reports, credit reports are $25. So when they get the information and then they resell it out there in the dark world of computer theft, that's what they can get by stealing your information. So really that's what drives a lot of the hackers, the actions they're taking to get the information so they can resell it on the black market. And that's what the motivation is, pretty much. So again, I'd like to thank you all for tuning in. We tried to keep this as short as possible. We could stand up here and talk probably another hour or two, but Terry said we shouldn't do that. So with that, I will turn the mic back to Michelle.
And I just want to reiterate what John just said. We thank you so much for joining us. I personally thank Jada Greenhow for her participation, John Gorel, because I think we make a splendid trio, right? And so we just thank you so much. But mostly, we thank you for really reaching out and wanting to get this information so that your agency can grow and it can maintain its ability to service clients. So again, we thank you so much.